All right. Well, we just appreciate everybody being here today. Today's presenter is Stephanie Petrillo, and I'd like to just tell you a little bit about Stephanie before we get started. Stephanie joined Disability Rights Iowa in 2022 after graduating with honors from Drake Law School. While at Drake, Stephanie focused on public policy and civil rights law and interned with nonprofits and government entities. This work highlighted for her how the issues people with disabilities face are connected and intertwined, and the important role that she has when advocating for her clients. Prior to law school, Stephanie graduated from Grandview University with a bachelor's degree in history and a minor in the Logos Honors Program. Stephanie's work at DRI includes helping clients with special education, employment, guardianship, and accommodation issues, as well as educating lawmakers on these topics. In her free time, Stephanie enjoys spending time with friends and family, reading and learning new things, and playing with her basset hound named Fred. So I'd just like to welcome again Stephanie. Thank you.
Thank you, Molly. Like she said, my name is Stephanie Petrillo. I'm a staff attorney at Disability Rights Iowa. Again, primarily I do special education law, helping parents and families of kids with disabilities. I do a little bit of other stuff too, interspersed in there. So today we're going to talk about navigating the chronic absenteeism law, recent changes, best strategies, things to keep in mind as we go through that process. A little bit about DRI, if you're not familiar with us. We are the state's protection and advocacy agency. There is one of us in every state and territory in the U.S. We are congressionally mandated and funded 100% by Congress and congressional funds. We were created in 1975, the P&A program as a whole in 1975, after an investigative journalist went into nursing facilities and kind of uncovered a whole bunch of neglect and abuse and did an expose on that. And Congress's response was to create the P&A system. So we're funded through 9 different congressional grants. We also have some private grants and donors as well, but majority of our funds are from Congress. Those are for later on. So we provide free legal advocacy and representation to people with disabilities for disability-related issues, and the list of potential topics that we cover are there. We kind of dabble in a little bit of everything, but we have kind of subject matter experts in each of these things. So disclaimer, I am an attorney, but I am not your attorney. This is not legal advice. I'm just here to kind of educate on what the law says and some best practices we've seen as we've gone through this. Another disclaimer is the legislative session in Iowa is still ongoing. That means there may still be changes to the chronic absenteeism law until last day of session. There has been changes recently in the last couple weeks. I think they just signed it in. But until the session is done and over, there can still be changes. So just keep that in mind. So in Iowa, children ages 6 to 16 generally must attend some form of education. And so that includes public school, accredited non-public schools, competent private instruction, which is usually some kind of like homeschool program where there's curriculum and standards, or independent private instruction, which is truly what you think of homeschool, of the parent providing direct instruction. The caveat with age 6 is that if you enroll your child at age 5 into kindergarten, then compulsory attendance applies, or at age 4 into preschool, then you're in compulsory attendance realm. You can wait till 6, but if you enroll earlier, then it kicks in. So this is the new chronic absenteeism process that was put into place last legislative session. It's broken down into, I kind of envision as 3 different steps. So your first step is when a student becomes chronically absent. That is if they are absent for 10% of school days or hours within a grading period. And so grading period, we are typically referring to semesters or trimesters. It's not the full school year, it's just whatever grading periods the school is broken out into. So if a student hits that 10%, the school is going to send home notice to parents as well as notice to the county attorney. The recent legislative change is that that notice to parents no longer has to be by certified mail. It can just be by general mail. Once a student hits 15%, this is when we're getting to what's called a school engagement meeting. The purpose is to identify why the child has been absent for that amount of time, figure out what kind of barriers are there. Are they school barriers? Are they home barriers? What's the cause of this absence? And try to identify any supports or services that could be put into place in order to kind of help alleviate those barriers. The team is generally made up of one person from the school district, the parent, and the student. And those three individuals will come up with what's called an absentee prevention plan. So again, it's looking at what are the causes, what are the strengths and weaknesses of the student, and each participant is assigned responsibilities in carrying out this plan. If the group does not or cannot come to an agreement on the absentee prevention plan, or if parents refuse to engage in that process, that can be the basis for the school to send a referral to the county attorney to pursue charges. If you do enter into the absenteeism prevention plan and violate that plan in some way, the parent can still be on the hook for referral to the county attorney. So when crafting these, we want to be really mindful that A, it's reasonable for the parent and the student and the school to carry those out, and B, that it's going to be helpful, that we're putting plans and services into place that are truly going to help that student and that family overcome those barriers. We can ask. So, right. So the question is, what if the school violates the absenteeism prevention plan? There is nothing in the law that says what happens. The language in the law puts the liability, I guess, solely on the parent. There may be other avenues to go through that, like if it's having a FAPE impact, there might be IDA Section 504 avenues to go with that. But in the truancy law, the language only talks about penalty to the parent. Question. Yeah, so the question is, has this new law kind of led to any changes that I've been seeing? The answer is yes. All of my special education cases are involving students with challenging behaviors. And so truancy issues come up quite a bit for one reason or another, whether it's school avoidance or the student is being pushed out of school by school administration, mental health issues, missing school for appointments, parent doesn't feel the child is safe to go to school, all kinds of reasons why we might be running into truancy issues. In the past, schools have been usually pretty good about working with us on those things and not heading down truancy route. This law kind of takes some of that discretion away from them, and it lays out this specific process. So we have seen an increase in referrals being sent to county attorneys. Whether that increase in referrals has also led to an increase in charges remains to be seen. I don't have the data on that. We're trying to get it. But county prosecutors have what's called prosecutorial discretion of whether they're going to bring these charges. So I think some are exercising that and saying, look, this is a kid with disabilities. They're missing school because they're attending all of these appointments outside of school related to their disability. We're not going to use our county attorneys have very limited resources and time and attorneys, and we're not going to use that to pursue this. Yes. Okay. Okay, so then the kind of third step on this is when a student is considered truant, and that's when we hit 20% absence in a grading period. So this is kind of where that discretion was changed in this new law. Before, it was discretionary to schools, and it was discretionary of how they categorized absences. This kind of takes some of that out of it and says that once you hit 20%, a referral will be made to the county attorney. And again, county attorneys have that prosecutorial discretion of whether they're going to move forward with charges from that referral. One change in this new law that just passed is if the school says that the absences are not impacting the student's academic performance, they now have a little bit more discretion to not send that referral. How much impact that's going to have, I don't know, because missing school has an academic impact generally. But I think that kind of gives a little bit more discretion. We'll see how that plays out next school year. Yes?
If you've got like a shared custody situation and it seems like the absenteeism is kind of resting on the choices of one parent but not the other, do you think both would still be charged?
That's a really good question. The question is, if there's a shared custody agreement and the absences are primarily responsibility of one parent versus the other, how is that handled? I think that's kind of getting, I think, into the criminal law area, not my area of expertise. That's kind of where I was going. Yeah, so educational rights, the parent who has, usually in a divorce decree or custody agreement, whatever it may be, there's a parent who has educational authority, educational decision-making authority. I think more, this is anecdotal, but more common is that kind of shared custody, 50-50, no parent is more responsible than the other. How that's handled, oh gosh, I'm throwing back to criminal procedure in law school, but I think there might be maybe like a mens rea, like an intent. You have to show that there was action or inaction. So I think if that's maybe falling to one parent versus the other, it's a fun little legal question. I'm not quite sure. Okay, so in the chronic absenteeism law, there are these exceptions. Some of them are new last year, some of them have been in there. So completed graduation requirements, obviously you're gonna be excused, you've met the requirements, and continuing education may not be necessary. If you're excused by court or judge, this one I think is a little ambiguous, and I'm interested to see how it plays out. Some of my clients have juvenile justice involvement due to issues at school. So I think there's a little bit of an interesting overlap there. And the actual language is by I think it's appropriate or competent court, and that's kind of odd legal language to me. But also if you're attending religious services or instruction, legitimate medical reason, which is one of the main ones I see with my clients, and then by reason of having an IEP or 504 plan that affects the child's attendance, again, major one for my clients. If you're attending private college prep school, there are specific exceptions in code for children who are deaf, hard of hearing, blind, or physically or mentally unable to attend school. There's some extra steps that come with those exceptions, but those are kind of for the more extreme side. or if you're a member of a religious group that is exempted from compulsory education as a whole. Again, recent legislation in the last couple weeks has added if you are applying for military service or engaged in some sort of military service activity, and then also if you're traveling to attend a wedding or funeral, those have been added now. Yes. Yes, question. I believe so. So the question is, does the wedding funeral exception take place next year? Generally, when laws are signed in, it's effective date of July 1 of the coming July 1. Yes. Yep. Unless the law says otherwise, most of Iowa's laws, when they're passed, will go into effect July 1 of the coming year. So I would have to go read the specific language, but I don't have any reason to think that they would have moved it up. Okay, so the two main exceptions that relate to kids with disabilities are the legitimate medical reason and reasons related to an IEP or 504 plan. The big caveat with this is the law leans very heavily on local control and local discretion. So application of these exceptions is really reliant on the school district's interpretation and definition of these exceptions, which kind of leads to some of the confusion we've had in my office with our clients and some of the conflicts we've had, because there's the Department of Education, and I've linked the guidance document that they have. They've tried to put some extra guidance around this, but it really is local control. So trying to make a uniform rule can be difficult. So legitimate medical reason, I've pulled these specifically from the guidance from the Iowa Department of Education. So they say if a child has been sent home from school due to an illness, that's going to be a medical reason. So the student has a fever, they're vomiting, they're coughing, whatever it may be. If the absence is related to that reason for being sent home, that should be covered. They talk about documentation from a doctor. They specifically say, obviously not all medical absences are going to require a doctor's note. The student has a fever for a day. It's not reasonable to expect the parent to take the child in to the doctor every time that happens. They also encourage schools to be mindful of healthcare barriers that families face if they don't have health insurance or they live in rural areas where accessing that healthcare can be difficult, or it's just transportation. The physician just doesn't have an appointment available that day. There's plenty of healthcare barriers, and they really advise schools to be mindful of those and not to expect a doctor's note for every single illness. And then they also say the law does not distinguish between mental health or physical health absences. It just says medical reason. And so their interpretation of that is that mental health is and can be a legitimate medical excuse for an absence. Related to IEP or 504 plan, this is, I think, probably the most confusing, or there are two different exceptions, but I think these are the most confusing ones for schools, for parents, for advocates. What does this mean? And the department tries to provide some guidance. It's still really unclear, and I think this exception is where I have most of my fights for my clients. So it is based on a connection between the child's absence and the IEP or 504 plan. Again, super vague. My best practices is get it written in the IEP or 504 plan that these absences are going to be expected, that they are going to occur. Because you can look at this kind of one of two ways. Some IEPs have said, okay, the student's going to be in school in the morning to get their academics, and then they're going to go to this third-party service to get ABA therapy or physical therapy or whatever it may be, and that is part of the IEP. So there's sometimes where an IEP will specifically prescribe that absence. But then there's times when it doesn't, when, you know, the parent or the student has frequent medical appointments that, you know, it's really hard to schedule those outside of school hours. And I think we've seen across the board, kind of, again, anecdotally, that a lot of parents have either proactively or reactively are scheduling their kids' appointments outside of school hours. Well, if you have the whole state of Iowa doing that, there's only so many appointments after school hours. I know very few doctors who take appointments on the weekends. So we've seen parents try to do that, but I think the more parents do that, the more difficult it's going to become. Again, there's just only so many hours in the day, so many doctors in the state. Yeah, so if the school is declining an exception, you could put that in a prior written notice. As an attorney, and this will be down the road, document everything. And so, yes, if I went to an IEP meeting and said, you know, my client's going to have a ton of absences due to all of these medical appointments, and the school says, okay, well, we'll figure that out, or, you know, we're not gonna say that those are legitimate medical reasons or whatever. I want that in a prior written notice. There is also, and we'll get to this a little bit later, but in the IEP, there is a section for parent concerns and comments. I always try to get it written in there that parent has a concern of, you know, the student's going to be absent a lot for XYZ reason, or that, you know, the parent is concerned about absences for whatever reason. That I kind of see as free reign almost, not totally, obviously within reason, but that's the area for parents to really put in their input. It doesn't necessarily become the IEP programming itself, but it's at least documented in that paperwork that is a parent concern, that they have discussed it with the school's aware of it. And then, you know, down the road, if it becomes necessary, that's another form of documentation. Yes. Yeah. It's all good. Yes. I think the answer is yes. Because there's a lot in the law that it's the school's responsibility to provide FAPE, to provide those services, to provide everything. There is a defense to that if the parent is the barrier, or becomes a barrier. So I think there's a bit of an argument. Again, I would advocate for it. I will advocate for just about anything my clients want. The worst that the school can say is no. And so I would absolutely say, you know, ask for, if they're gonna miss 30 minutes of speech, then, okay, can the speech therapist stay 5 minutes later? Like you said, it's a known appointment. Can we just not schedule speech for that day? So I think there's ways to problem solve around that. But when it comes down to it legally, if the parent is the one pulling the student, I don't know that the school necessarily has the responsibility. There might be and I'm arguing against myself here, but there might be a FAPE argument too. No.
Okay.
No, a one-time, a once-a-month absence, you're not completely denying services.
More often though, like let's say I have a client right now who's missing a lot of school, and they're saying you're declining special education, you're revoking consent because you're not in school, so we're not going to provide these services anymore.
No, revoking consent needs to be in writing, so just not having the student in class is not. Yes, please. Okay, there was a question over here. Yeah. Yes, all of the above. Yeah, I mean, if you're gonna make an accommodation for it, like if the student is absent and you have a plan for how that student's gonna make up the work that they miss when they're gone, maybe an accommodation. If you are going to, if it's a week that you know the student's gonna be gone, and you will preemptively address that through additional SDI minutes elsewhere. Maybe that goes into prevention strategies. I think it can go a lot of different places just depending on how you're responding to it. There's other information. There's at the beginning it's like factors that affect the student's education, and usually you see like assistive technology or social emotional behavior or language in there. I'm not super familiar with the back end of Achieve, so I don't know if those are drop downs that checkbox. Okay. I think there's a lot of places to put it, and especially if the school's willing to work with the family, that can very easily be written into the plan in multiple places. Where I talk about the parent concern box is if a parent is dealing with a school that is really not working with them, that's kind of that's a place where the parents can have their concerns documented, whether or not the school agrees with them. Okay. Let's see, I think. Okay, so interesting absenteeism considerations for kids with disabilities. If a student's absences are due to their disability or it's impacting FAPE, we may have some IDA 504 violations. Emphasis on may, everything is fact-based, very individual situation-based. Data-driven, absolutely. So if the student has not already been found eligible for IEP or 504 plan, we may be triggering some child find responsibilities. There's repeated absences, and maybe it's due to school-based anxiety, and they have a diagnosed anxiety disorder. If it's not being addressed by the school, we might have some child find issues. No.
Also, I think it's important to remember that Iowa is a non-categorical state.
Yes.
So just because you don't have a diagnosis from a medical doctor doesn't mean that you would not qualify for special education supports and services.
Absolutely, yeah. Iowa is a non-categorical state. We are the only non-categorical state, and I am so thankful that we are not. I go to national conferences and hear about all the fights people have about what category and the extent of services and the funding, and it makes my head spin. So yes, we are non-categorical. You do not have to have a diagnosed disability. Iowa looks at is discrepancy between peers. So yes. If it's something that should be or can be addressed by an IEP support service or in a behavior intervention plan or whatever it may be, there are a lot of things that IEP teams can do to address these absences, and if they're not, we may have a FAPE violation. it may suggest that an FBA or a BIP are necessary. I feel like I'm talking to a room full of people who understand the acronyms, but if you don't, please let me know. It's a land of acronyms, and I don't always know where people are at. But if it's a behavior-related issue, we may need an FBA and a BIP. It may be avoiding certain tasks. It may be access to something, or a sensory issue, whatever it may be. What's that? Trauma. Absolutely. Trauma is a huge one that I see a lot with my clients, and there is a FAPE obligation of schools to address trauma, and especially trauma that comes from the school setting. So I think that's a huge factor, at least with my clients. Again, I kind of see the worst of the worst. And so those are things that may indicate that we need an FBA and a BIP. And it may trigger, we just need a new evaluation. Like there's something going on here. We don't know what it is. It's time to reevaluate. There is no limit on reevaluations if the school agrees. The only time is if a parent asks for it and there's already been one in that school year, the school can say no. They can say yes, though. Like it doesn't say you can't do it. It just says the school may decline it. Yes, and then an IEE, which I love asking for IEEs. And failure to address chronic absences may be a denial of FAPE. I think that's kind of what I'm getting at here. It may also be the absences may not have anything to do with something that the IEP or 504 plan can address, but they're missing services, they're missing instruction, they're missing SDI. That may be one of those barriers to receiving FAPE. And again, the school is responsible for addressing those. So dispute resolution options available. When it comes to chronic absenteeism, the law does not spell out any avenues for parents to seek dispute resolution based on, most often what we see is the school misclassifying or refusing to use one of the exceptions. There's nothing in the law that gives any kind of dispute resolution mechanism. So if you're having disagreements about the application of the exceptions themselves and kind of the ins and outs of the attendance policy, you can go to school administration, go higher up, go to the boss's boss. You can try to go up that ladder. You can bring your concerns to the school board. The school board is the one writing the attendance policy, so you can bring it to them in open meeting or through email or individual meetings, and try to talk to them. I think what we're kind of hearing, again anecdotally, in the field is that a lot of schools are trying to figure this out, and a lot of situations have come up this year that they did not anticipate and that don't really work with their current policy. And it seems like schools have been ironing those out as we're going along. The kind of sense that I'm getting is we had a lot of conflict early on and schools are figuring it out. So there may be room for parents to step in and advocate and just have that discussion and be at that table discussing that policy of, I had this situation and this is how the policy just did not work. So have those conversations with your school board, with the people making those policies. Getting input from outside providers, doctors, therapists, service providers. If your student is missing school to go attend those things, or those providers are working with that student to address why, it's a therapist and your student has severe anxiety, that therapist can speak to that severe anxiety. It's actually in the Iowa Department of Education's shortened school day checklist, which I am a huge fan of. It says in there that medical providers are key essential sources of information and should be considered when the IEP team makes decisions. That to me suggests the Iowa Department of Education's view, and I don't speak for them, this is purely me speculating based off of those statements. But to me, that says that the Department of Education wants school teams to take in all of that information and truly consider it. So if you're getting letters, if you're having this issue, again, document as much as you can. Pull in those physician letters, pull in those therapist letters, pull in letters from speech and OT or whatever services your student's providing to really provide that fulsome picture of everything that you're doing to help your child. That will also be super important if, for whatever reason, you end up down the line in truancy proceedings. You can provide all of that. Say, look, we're doing all of this. We're trying. Like, we're truly trying. We're not being negligent parents. We're not just letting our kids sit at home play video games. We're trying. So that's part of the documentation piece I talk about, just to be as much paper and from people who know your child.
Where can we find more information about shortened school day?
Yes, so Iowa Department of Education, if you go to their special education page, there is, you have to scroll down a little bit, but there's a tab that says state guidance. And then on that page, if you scroll down, there's a policy and practice webinar series. And I think the second or third one in that series is on shortened school day. I refer to that presentation and their comments in it and the checklist that came out of it a lot when I work with shortened school day students. There's a webinar, they have their presentation posted. There's a checklist for when shortened school day is due to medical reasons and non-medical reasons, and then there's a homebound checklist as well. They have their presentation posted. I usually just go to, in the presentation, her name is Rachel Bosovich. She's one of the main attorneys in dispute resolution. When she's talking about shortened school day, especially related to behavior, I just kind of fast forward to that session. Okay, AEA mediation may also be an option. This is, essentially it's an IEP team meeting with an AEA member who's not been part of the team, kind of coming in and facilitating the IEP meeting. They can be helpful, just kind of get an outsider's perspective, gets a neutral party at the table to kind of just sit down and talk with everybody and provide new perspective.
I think it's important also to remind everybody that the AEA no longer provides advocates. So if you are
Yes.
you should probably bring your own. Don't ever go into these things without some support, whether it's a professional or a family member. It's always good to be able to take off that hat of emotion and have someone else there that can
Yep.
really take notes and be very objective about what's going on.
Yeah, the AEA advocates have actually now gone to Ask Resource, so reach out to them. So yeah, and reach out to them. You can reach out to us. I will say I am one of 1.5 attorneys at DRI doing special education work, so we're kind of limited on how much we can do. I'm always happy to answer emails, just quick, here's the process. That doesn't mean I can represent you at these things, but I'm happy to provide technical assistance. And I'll have my contact info later on. Okay, disagreements related to strategies and services to address absenteeism. This is when we're getting back into the IDA and 504 world. And this is when your typical dispute resolution procedures through like parental safeguards kind of come in. So we're talking state mediation where you ask the State Department of Education to send in a mediator and everybody sits down at the table. You can file a state complaint or due process complaint. State complaints do not need an attorney. Due process complaints don't need an attorney either. highly recommend an attorney for due process complaints. It is a legal proceeding. It is a legal process. I don't recommend going at that alone. DRI, we can help with all three of those: state mediation, state complaints, or due process complaints. Again, yes, we do handle due process. Yes, DRI services are completely free for families. Again, it's 1.5 people, so I'm trying. Yes. Okay, strategies and best practices. I've gone over a lot of these. My biggest one is just document. It can get frustrating. A lot of my struggle is when there's a lot of phone calls about things that I think are IDEA violations, and I can't do anything about it. If it's not documented, it didn't happen and it doesn't exist. So if you do have a phone call or a face-to-face communication, something that is not written, I always recommend that people follow up with an email of, hey, I just wanted to check in. We talked about XYZ. This was what you said. This is what I said. This is what we're going to do going forward. That gives them the opportunity to either respond back and say, no, that wasn't quite my understanding, and then you can resolve things before they become bigger issues. It gives them the opportunity to say, yep, that sounds great, or they can just not reply, and you still have documented evidence. Document reaching out to service providers, just over document. I always tell clients, send me everything you have. I would rather read through 50 useless emails than for there to be one great email in there that I could use. Address absenteeism early and often. Communication is vital. It's just on both ends. It has to happen often. It has to happen clearly and honestly and transparently. Develop a system that the whole team uses for communication. Often I will have 6 different text chains that I get screenshots of, and 24 different email chains, and it works, but it's really difficult to keep everything and everybody on the same page. One thing I've seen work really well is just a Google Doc with everybody. Everybody has access on the team. They can put in their notes. It has tracking that shows who wrote what comment. It has what time the comment was made. It has all of that detail and information that can be helpful down the line. Again, write it in the IEP or 504 plan. Accommodations or modifications, strategies and services. The expectation that the student will be absent, if you can, again, probably in the parent concerns section. But that's huge to get in there. Plan for how instruction and work will be made up due to absences. That is probably a huge one, especially for our older kids. They missed 3 days in a row, and now they're super anxious about coming back to school and catching up on everything that they missed. And it snowballs, and it gets really out of control. Yes, especially as they get older. I would say most of that is my high school clients. You're talking about they're getting grades, they're getting credits for graduation. Like it can truly snowball out of control. So having a plan of where's that material going to be? Who does that child go to get caught up on everything that they need? Are we talking extended deadlines? Are we talking reduction of that kind of busy work that's not necessary to show mastery of the subject? Yeah. Yes. Yep, okay. And then getting to the root cause of the absences and eliminating them if possible. Anxiety, I keep talking about that one because that's a huge one that I see as the reason why students miss school, is just anxiety about school, about tests, about learning, about peers, about teachers, whatever it may be. It's a huge one. And there's a lot of, there's strategies out there to addressing school-based anxiety, and just trying things. Yes, counseling at school. I'm a huge fan of counseling at school. I know that that is a limited resource in a lot of places, and that's unfortunate. But I'm a huge fan of that. Are we talking? Is there self-confidence or bullying and harassment issues? If that is becoming a barrier to FAPE, that's something the IP team needs to address. Safety concerns and school-based trauma, we talked about that already. Those are huge secondary effects of different things in school. How are we incentivizing the kid to come to school? How are we making it a welcoming place for them to be? I have a very long list of trauma-informed resources that I send out to usually the attorney for the school that I'm working with. But there's a lot of, it's ATN, Attachment Trauma Network. They have a ton of resources of trauma-informed schools, creating trauma-informed programs that they're kind of universal design. It's not just for that student with disabilities. It's implemented school-wide. If they do, I don't know of it.
I've tried to find it, and I've connected with a couple of people that were on the list and didn't get any response.
Okay.
Well, I mean, that was a few months ago, but yeah.
Yeah. And then do we have accessibility issues? Are, not just physically accessible that you think of like mobility and wheelchairs and doorways, but are we expecting that student to show mastery in ways that are not accessible to them? Again, I go back to anxiety. If the student has severe anxiety and we're expecting them to stand up and give a presentation in front of the class, if it's not a public speaking class, if standing up and presenting to peers is not what is being graded, can we find other ways for them to show their mastery? Can they record a video? Can they go into the teacher and just give it one-to-one? Can they give it to a couple of peers who grade them? PowerPoints, can they write a song? Can they write a poem? There's so many ways to show that mastery to address that anxiety. And we can sort of get around those. It's really, there's, Dr. Ross Green has the collaborative proactive solutions method, and it really, the adults get together and say, hey, so-and-so has this very specific issue in this very specific subject. And they kind of talk about, they list out what are all the issues that we're seeing with specificity. And then you go to the student and say, hey, I noticed that you have a really hard time waiting your turn to answer a question in math class. What's up? And then you just have that conversation with them and let them tell you why that's difficult. Let them tell you strategies and ideas that may be helpful. Some of them may not be super reasonable or doable, but it's having that conversation and engaging with that student one-to-one and letting them come up with their own solutions that then get implemented. So they're working with us. We're not dictating to them what's going to happen. We're kind of giving control back to them. Collaborative Proactive Solutions, CPS. So he has his like broader organization is Lives in the Balance, I think is the website name. But I've gone through his training and try to use it or encourage IEP teams to use it. Okay, if you do end up with truancy charges, don't call DRI. We don't do criminal law. We cannot do criminal law. Our funding statutes are very limited in what they allow us to do. Go hire a defense attorney or ask the court to appoint you one if you can't afford one. You want an attorney. If that attorney is not familiar with special education law or special education, the world of special education, they can call us and we can give them general here's what the IDA says, here's what 504 says. We can give them that kind of technical advice, just professional to professional. Yeah. So truancy charges are criminal charges. Yeah, truancy charges are, it's a misdemeanor. They're criminal charges. So you are entitled to be appointed attorney if you cannot afford one. Maybe, maybe not. That's why you have them call us.
It's also, from experience with truancy court, it's not that scary, and,
Do you find the judges are able,
what?
do you feel like the judges are able to, like, kind of empathize with the families, or?
Yeah, you get an opportunity to share your, I felt very much like our school was using it to try to get us to sign away our rights for the IEP, revoke the IEP, and just go to, homeschooling, which we didn't do. We went to truancy court and said, truancy court was less scary than the IEPs that we've seen. So, we went without an attorney and asked for one to be appointed. One was appointed. We haven't had much contact with that, but I do have lots of documentation, lots and lots and lots of documentation. So, judge was very understanding in our case. So,
I'm happy to hear that.
Yeah.
and these are criminal judges, not juvenile court judges.
Yes, because the charges are against the parent. The parent is the one being charged. So inform your attorney about your child's disability, their IEP 504 plan, what steps you've gone through, the whole process you've been through. These are questions that a good attorney should be asking you anyways, but be prepared to share all of that information with them so they have the full picture of what's going on. Again, if they have zero idea about special education law, they can make a professional inquiry to DRI. We can have an hour-long phone call and give them a crash course on SPED. My general opinion, and there's obviously exceptions, truancy, when it comes to kids with disabilities, is probably better addressed in the IEP 504 school process. I have yet to have a client have a helpful outcome in the court system when it comes to the issues that I am helping them with. So generally, we can get a better outcome. I've not seen criminal court involvement help a family. Okay, that's a lot of information. There's that's my email if you have questions. If you think you have a case that you'd like DRI's help with, you can go to our website and submit an online contact form, or our phone number is right there too. We have a marvelous intake team.